I'm Don Kochersberger with Business Law Southwest. I am the person who coordinates our litigation department. I'm going to talk to you a little bit now about restraining orders. We get clients or potential clients who come to us and their goal is to stop someone from doing something that they're doing. Usually in a business situation, that could be something like closing down the business or behaving and running the business in a way that's not proper. A restraining order is a way to prevent some action or coerce some action, it can be either direction, during the time that it takes to resolve a lawsuit. That's a restraining order. They're at the beginning of a case, and they're there to preserve what you call the status quo. Basically, to make sure that the things that are being done properly continue to be done, and that if there are things being done improperly, that they are stopped. It's not a simple thing. It's a pretty extreme remedy for a court to issue a restraining order. That's not to say that they don't happen, but they are used sparingly. And there are very specific requirements that you need to present to the court before a court will give you a restraining order. The most important one, and the one that is something you have to be absolutely sure to prove, is that the behavior that you're trying to stop, had it continued, could not be remedied with money. It's what they call irreparable harm. Something that's going to happen, and if it happens, it can't be remedied by the court issuing a money judgment to the people who are wronged. And that's not always as easy as it may sound. Lots of things can actually be addressed with money, at least from the court's perspective. So oftentimes what you're trying to do is show that the business itself will be so negatively impacted that you can't quantify the amount of damage that is done. You also have to demonstrate that you're likely to win the entire case, which requires putting on an evidentiary proceeding, showing the judge your evidence, or at least some of it, to convince the judge why it is that you're likely to win the case. Because if you don't prove that you're likely to win the case, you're not supposed to get a restraining order. The other term that you may hear is an injunction. And sort of colloquially, an injunction seems pretty much like a restraining order, and in fact, it is. The injunction can be a preliminary injunction, which is essentially almost the same thing as a restraining order, or it can be a permanent injunction. So if you filed a lawsuit and one of the final relief items that you have is to stop somebody from doing something, you can get a permanent injunction. So if you hear those different terms, that's how they differ. The requirements for an injunction or restraining order, preliminary injunction or a permanent injunction, they're all governed by the same rules and the same law, and you need to prove the same types of things in order to get a judge to give you that relief. So if you feel as though you're having a problem that can only be solved by a judge stopping somebody from doing something or forcing them to do something they're supposed to be doing and not doing, it's a good idea to talk to an attorney who can then analyze that with you and determine whether you're likely to succeed on something like that.